Good afternoon, Judge Siwendu.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm very well, thank you.
Oh, I'm happy that you are very well, so you are in a position to handle whatever questions come your way.
I have no choice.
Thank you very much for availing yourself for this interview,
Yes.
for consideration for one of the positions in the Supreme Court of Appeal. We appreciate you availing yourself. I am going to ask you some questions, and after that I will allow the Deputy President of the SCA to ask you questions, and then the Minister and other commissioners.
Yes.
And as we do so, we will be bearing in mind the selection criteria that we have adopted for the selection of judges. We may be very robust with you at some stage, but there's nobody who intends to humiliate you or anything like that. We will treat you with respect and courtesy. Are you ready for the first question?
Yes, thank you, Chief Justice.
Okay, all right. Thank you very much. You hold the degrees of Bachelor of Social Science and LLB, is that correct?
That's correct, Chief Justice.
And you got the junior degree from the University of Cape Town, is that correct?
Yes, with an honors, Chief Justice.
With an honors?
Yes.
Hey, you are right to emphasize, I overlooked that. Yes, and then you did your LLB at the University of Natal, is that right?
Now KwaZulu-Natal, yes, Chief Justice.
Now KwaZulu-Natal, yes. And then you, after doing your articles, you were admitted as an attorney, is that right?
That's correct, Chief Justice.
And you were admitted as an attorney, is it in 96, 95?
That was 95 November, Chief Justice.
Yes. And then in your law firm, how was the diversity of work that you did during your time as an attorney?
Where would you like me to start?
Just give me an idea in terms of branches of law, the cases you did, customary law, patent law, trademark law, commercial law.
Well, after I served my articles at Cheadle, Thompson and Haysom, I then moved to Durban and worked in Pietermaritzburg in that office for a while before the office closed down. There, I focused on mainly labor law litigation in the then industrial court. And we did work for various commissions around the health sector strike, the famous health sector strike then. And around 96, after that office closed, I then started my own practice in Durban. And my practice fortunately focused in, commercial work, in the way of mainly property law, leasing law, and later on I was instructed by various departments in the government of the province to draft particular legislation in relation to the tourism sector. I then branched to do a lot of commercial litigation for various companies, and I think I've listed some of them. And for me, the backbone of most of our work revolved around Transnet in particular. This is when the interface between state contracting and company law and public law was starting to get invoked. So they were a backbone of most of our work. And it built up from there to attending to work for Eskom and also some of the oil companies, Engen and BP in particular, and thereafter including some of the banking sector in KZN, which included business partners. It was small business partners then, And it was small business partners, now it's business partners, and also banks like Itala. And of course, the property arm of my practice included most of the banks. As the practice grew, we were called to attend to some work here in Johannesburg. We did some work on certain measures, and for SAA in particular. I think everyone knows the famous VA.com debacle. We were asked to help to exit those contracts. And we also were called in to assist with the restructuring of the electricity industry. And then the contemplation was to form regional electricity distributors. That's broadly, some of the work. And as the BE trajectory took foot, we were assisting smaller businesses who were entering into joint ventures with some of the bigger companies. And I did forget to mention that for a while, I was also advising the regional business body, NAFCOC, in Durban. So that's broadly some of the foundational work that I did in those early years.
I forgot to mention that you and I know each other outside of the judiciary while you were still practicing in Durban.
That's correct,
So
Chief Justice.
I'm just mentioning it so that it's out there. And I think we lived in the same suburb at some stage.
Yes.
Yes.
I think we still do.
Oh, we still do?
Yes.
Oh, okay. Well, probably some people have got properties in Gauteng and Durban. Okay, all right. Then you were appointed as a judge in Johannesburg, is that right?
That's correct.
And that was 2017?
That's correct, Chief Justice.
Yes. That means you have been a judge for about, 6, 7 years?
I'm in my 7th year, Chief Justice.
You are in your 7th year.
That's correct.
So it's 6 completed years.
That's correct, Chief Justice.
Okay. Joburg is a very busy division.
Yes.
How did you find work as a judge in the Johannesburg High Court?
It is an extremely, extremely demanding division. I think I did better as an acting judge in some ways than, as a full-time judge because of the relentless hours and relentless workloads of all sorts. And I suppose I can safely say that there is nothing that hasn't got its own advantages and disadvantages. Because with that avalanche of work with a small complement of judges, one got exposed to a range of complex matters in a very short space of time. So, yes, and I'm hoping that we will get to this, but part of it is also for me, coming from private sector, the back-end support is not as helpful as it should be. Yes, thank you.
Of course, Johannesburg High Court has got really a wide range of matters. It's one of the divisions where if you are a judge there, you will really get exposed to all kinds of branches of law. Is that correct?
It is correct, Chief Justice. And I must mention also that in most instances, that work comes in from the agent court. And you've got to cut through the issues quickly and then obviously produce judgments timelessly as well. So, yes, you are correct.
And bearing in mind the background that you had in terms of your practice, did you find it quite easy to deal with the diversity of work that you find in that court?
Well, my process, what I didn't mention is that my practice in 2012 merged with one of the big law firms, and that's how I happened to be in Johannesburg in the first place. This is where I was spotted, and by then I had been working for years with various boards of listed companies, and also served as a director myself of some of the blue chip companies. And so when it came to having sat with sometimes hard-nosed business women and men, when it came to more the commercial side of it, I wasn't frozen by, those type of disputes. But it, of course, did take me a time for conversion to come into the chase of procedural aspects and obviously, civil litigation. And also because I had left that work behind almost some 12 years ago. And I think criminal law, but I got into criminal appeals very quickly. I can safely say that having spent time, at least the first 3 years were very difficult, but thereafter I was able to find my feet. Thank you.
So we were told earlier on this morning by a candidate who comes from a division in the Eastern Cape that when you are in the division in which he's based, you don't get a lot of diverse work. But I would imagine that when you are in Joburg, it's the opposite. That's where you get the cream of work that many judges would like to be involved in.
Yes, it is true. It is true. But then when you are in other divisions, you get to write better judgments.
Well, okay, no, that's fine. Now, tell me, within the period that you have been in the Johannesburg High Court, 6 years, have you had a chance to deal with cases where you are asked to declare legislation to be inconsistent with the Constitution and therefore invalid?
No, not.
You have
but
not.
However, I've been part of a full court that dealt with a different issue, where policy was challenged as constitutionally invalid, and that involved Section 15 of the Constitution, and it was a right to freedom of religion in the school sector. And I may also just add that at the SCA as well, I was involved in a matter where a housing policy of the city of Cape Town was challenged. Yes.
Yes. How many acting stints have you done at the SCA?
I've just completed my 5th continuous sitting stint.
A stint or term?
Well, I've acted for 5 terms.
Or for 5 terms,
Yes,
yeah.
yes.
But was it one continuous or it was broken?
It was a continuous.
Okay.
Otherwise, I would not have been able to sit here if I had not been given that opportunity.
Okay,
Yes.
so that means that it's a year and a term. that
It's
you have
been a
spent.
year and a term. That's correct, Chief Justice.
Yes. So in the High Court, you have basically done about 5 years and a year in the SCA plus something.
No.
Uh-huh.
I was appointed in 2017.
Yeah. Remember, you said earlier on you have been in the High Court for 6 completed years.
Yes.
So you have told me now a year and a term you were in the SCA. That's why I'm saying
Yes.
that must mean that you have been in the High Court in terms of actually working, if we take out the year in the SCA, that's
Yes.
5 years.
It could be that's
Yeah,
correct, yes.
because
I got there in June.
Because you spent a year in the SCA and a term.
That's correct, yes.
Yes. How did you enjoy your stint in the SCA?
It's a robust court. It's a tough court. The first term was in the middle of winter, and my body went into trauma completely. And I think the sense of, that when you are there, everybody is looking at exactly how you got there. And I think the pressure of being on the spotlight was very challenging first term, but I soon got my feet under the table, and it's been the most invaluable experience I could have ever had. It's long hours and it's highly intense. You're not on your own. You are writing for a range of people. There are a range of competing views around the table. But I have learnt a lot from it, and I've benefited tremendously from being in that court.
Okay, let's go back to my earlier question about cases where you may have been asked to declare legislation constitutionally invalid. You said
Yes.
you haven't had a chance to deal with that as such. You have dealt with one where there was some constitutional issue, but not being asked to declare legislation invalid.
Yes.
But are you familiar with what a judge is supposed to do when they have that kind of case where they are asked to declare legislation invalid?
Yes.
Are you familiar with what to do and how to go about it?
Yes, I am.
Okay, please share that with the commissioners.
Yes. Well, you look at the provision itself, and you look at the extent of the inconsistency alleged with the terms of the Constitution, and then you determine in what respect that piece of legislation is inconsistent with the constitutional provision. Once you arrive at the conclusion that it is, then you decide to what extent that provision can either be saved or not saved. And obviously, depending on what the issue is, if, for example, the issue is perhaps maybe a question that it's ultra vires, it's a different approach. If it's a question of discrimination, of course, the limitations clause comes into play, into the consideration of whether or not there is a justifiable limitation of any particular right that is conferred by that legislation. Broadly, that's what I think would happen. And you have to be clear about the extent of that invalidity.
And then, are you familiar with the two types of discretion that we have in law?
Well, I must confess, one of the joys of being amongst the last is that I have...
You have?
I'm saying I must confess, one of the joys of being amongst the last candidates is that I've been listening to this debate.
So you have had all the time to check?
Well, I think I want to make it alive, because one of the cases I refer to in my bundle exactly involves this question of exercise of discretion. And I think
Did you start listening yesterday or only today? Yeah.
I'm not going to...
We want the truth now.
No, I'm not giving all the secrets, but I've been following the debate.
Okay, all right.
Yes.
Yes.
So, I think Commissioner Ngugaitobi has been pointing to Trencon, right, as the case that deals squarely with this question of what kind of discretion is there. But I want to bring it more closely to something that I would have dealt with. And that involves a declaration of invalidity of a contract under Section 71(2) of the Constitution. And 71(2)(b).
71(2) or 172?
172, I beg your pardon. Yes. I'm now starting to sound dyslexic, but yes, that's correct. So, after a declaration of invalidity, a court is being asked to determine what is a just and equitable remedy, let's say in the context of a contract. I did exactly that in a matter, and I was set aside by the full court in relation to the exercise of my discretion there. That provision provides for a true discretion in the sense that a court is at large to determine to fashion an appropriate relief, as it were, that fits with the circumstances. My exercise of discretion in a matter of vision view production, and I think I've included it in my schedule of matters, was set aside on the grounds that I had not applied a correct principle of law. And that correct principle of law arises from all pay, and whether or not the gains made flowing from an invalid contract can be retained by a party. And I understand that the full court decision was set aside fairly recently by the SCA in a matter that has now gone to the CC. So there is that kind of discretion where a court is being asked to fashion whatever relief is appropriate in the circumstances, and that I understand it to be a true discretion per se. And of course, there's the other side of a discretion where a judge has, based on the provision and the power, has desperate choices to make and can choose any of those choices. And more recently, I actually learned, I think it's in July, that in a matter of DBS, in fact, I recall calling this colleague who had scribed this matter. It involves a salvage. And in that matter, I got to learn that actually there's a third discretion. So there isn't always this binary approach. One has to look into the provision. I was quite surprised. It was in July when the matter came out. And I was quite surprised. And I called this colleague, he's at the CC at the moment. He said, I'd never known that there's a third discretion. And as I said, I will still need a book. I'll still need the case to look at in order to know how to apply it. Thank you.
Okay, but let's go back. Are you able to say this is the one discretion, this is the other, these are the features of this one, these are the features of this one, and this is the legal significance of the distinction between the two?
Well, in the first type of discretion, where there is disparate commensurate choices that a judge can make, I mean, they're making a value judgment, of course. They can arrive in any choice that they can based on that, but that discretion really needs to be exercised judicially within the confines of the law. But in the sense of a true discretion, as I understand it, there is no particularly wrong choice per se, but the limiting factor of the exercise of that discretion is that the court must apply the right principles of law, and the court must find its exercise of discretion based on correct facts.
I will now give the opportunity to the Deputy President of the SCA to put questions to you.
Thank you, Chief Justice. Good afternoon, Judge Siwendu.
Good afternoon, Deputy President.
Shall we zoom straight to paragraph 16(1) of the questionnaire?
Sorry, I've got the wrong.
in which reference is made to two annexures being A1 and A2.
Just give me a moment. There are two bundles here that belong to previous judges. I thought they were mine.
Please don't speak away from your mic.
Yes. Oh, okay, there we are.
You can bring it closer if necessary.
Thank you. Please bear with me, Deputy. I'm on paragraph 16, yes.
Yes, I want you to go to the annexures, annexure A1 at page 13 and following.
I am there. Thank you, Deputy President.
Looking at your list of judgments, are you able to tell this commission which ones you believe, would you say, introduce new principles of the law or dealt with new or developing areas of the law or reserved or resolved uncertainties?
I think I'd start with the first judgment, Israel Member District, which I penned whilst I was at the SCA. I do note there that the judgment, of course, deals with the subordinate rulemaking, and I think those principles are obviously trite, that the rulemaker must act intra vires. But for me, what was important about that is that the judgment also raises, in considering a delay in bringing the review, it raises the point that if you are dealing with a regulation, for example, or subordinate legislation, its direct external effect may only sometimes be known through an ongoing application of that. It may not necessarily be known from the time of the promulgation of the regulation. And so it emphasizes that principle that when you consider delay within which to launch the review, the direct external effect needs to take into account the ongoing application of the regulation. I think perhaps maybe the next one, Kamane. I don't know that it particularly introduces a new area as such, other than to really emphasize that in matters of domestic violence, where, for example, a perpetrator is charged, that the Section 3 of the Domestic Violence Act integrates, as it were, Section 41Q of the Criminal Procedure Act, and that correctly, the definition of violence under the Domestic Violence Act is not bounded as compared to under the Criminal Procedure Act. And the reason is to emphasize that the reason is to give maximum protection to the person experiencing or seeking relief under the Domestic Violence Act. I think that I've included in my bundle the Living Hands matter, and I must confess I am beginning to wonder about the wisdom of it, but I will raise what I thought was important since the matter has gone on appeal. But I will raise what I consider to have been important for me. We know that under delictual principles, the question of extending pure economic loss is a question of policy, right? And in this instance, I deal with two important principles. The one about causation, and I think that I determined that in the context of an investment setting where what I classify as social security funds is concerned, the principles of causation must really consider the extent to which the risk has been created, which exposes the funds to dissipation. And I also deal with the question, I know that I was asked to extend the principles of common law to deal with this matter. Of course, I declined to do so, and I will explain. I'm sure there's going to be a debate about that. And I say there that legal policy already accommodates for an extension of liability where you are dealing with these vulnerable groups and social security funds in the classification of the funds. And I consider the matter obviously important. And I've included the Competition Commission versus Coca-Cola Beverages, and one of the counsel in the matter is obviously here, and he succeeded before me, and it was a very interesting matter I wrote for the appeal court. And in that matter, you remember, under the competition law, there is the safeguard in relation to various public policy criteria under 12A. In that case, I was asked to deal with the nature of the review powers under the Act, and I considered that in relation to the rules, and that happens in the context of a measure. And it was also to confirm the test, because only the tribunal had dealt with the matter. And we confirmed on appeal the test of whether a retrenchment is measure specific or not. And there I unequivocally reject the causal connection test, and I found that the incentives of the employer are directly connected and highly implicated, not directly connected, but have a nexus with the measure. And I think the matter is of importance. I'm not going to deal with Southern Sun, because really it doesn't raise any novel question of law. But I want to talk about, on page 16, BB Market's rooftops, very interesting matter. Sadly, the matter didn't proceed later. There, I granted an amendment. And the beauty in that matter is that the terms of the amendment were being squarely argued before me to develop common law. Counsel was suggesting that I adopt an English law principle, and this is about disgorgement of profits that flow from an unlawful termination of a contract. And in that matter, I was setting out the principles of why that amendment would be granted, right? And I was directing the court that was going to hear the matter on some of the parameters for considering that constitutional issue of extending common law. And that criteria is set there. I don't want to take too much time. One of my other matters that I think is, in fact, I'm just going to raise maybe 3 more, if I may. I'm not sure if I'm taking too much time.
Well, you must just listen to the Deputy President of the SA's questions, and
Yes.
he would indicate what he wants you to address.
All right. So let me just proceed. I mean, one of the judgments, I'm now on page 17. It's BF and RF. It was a dissenting judgment, and it's in the context of an antenuptial contract. I know that there's been some commentary around that, and I'm hoping to address it in due course. But here, there was no principle of law that applied to the interpretation of this particular contract, because there was a conflicting view on the facts in terms of whether or not the certain shares, it's set in a commercial context, and parties had brought a stated case in order to determine whether the assets and liabilities in relation to these shares formed part of the estate for the reckoning of the accrual in terms of the antenuptial contract. I find, in my dissent, I'm of the view that the Matrimonial Property Act decidedly doesn't confine assets to tangible assets. And this would have allowed anyone who had, for example, a right of first refusal or an option to climb in and say, look, that asset it can't be included in the reckoning. And I determined that in this particular case, absent the factual background that is required in terms of what the intention of the parties were in this conflict, it's not appropriate to determine the matter on a stated case. And I was asking for a re-referral, and particularly because there were serious policy issues for interpretation around the question of the meaning of assets, for example, in this matter. And I felt that barring absent the evidence of context, and I do refer to Endumeni in the judgment, but I don't regurgitate those principles because I consider them as tried, and I refer and I suggest that it be referred to back for evidence. It was a very interesting dispute precisely because the law is not clear on the matter.
Don't deal with those that even you don't regard as important in terms of legal principles.
Yes.
The ones that we are interested in terms of that list are the ones that you are able to say, you say they are important because of their legal significance.
Right. I'm left with two. The last two. One is ex parte KF and others. And this was a sequel following a refusal of a surrogacy agreement. The law, there are no principles defining suitability of a surrogate, of a host mother. And I was developing the law further to set out the criteria of what both the psychological and the emotional components, and that judgment is being followed. What I didn't note in that judgment is that I also addressed intersecting rights of whether an embryo is a child to be born. And I've since received some articles saying, actually, I adroitly dealt with the matter to avoid a quicksand of whether, because there are other intersecting rights to terminate and for genetic selection. The other last one is obviously my dissenting judgment in the Chamber of Mines, which was one of my first biggest challenges, dealing with the once empowered, always empowered principle. I differed with my colleagues, and this is around the standing of the charter, the standing of the mining charter in our law. I must end there.
Thank you.
And whether the charter is a binding force in law, particularly in the mining charter.
You no doubt are aware that the Supreme Court of Appeal is the National Appellate Court, and that it is expected of it to give guidance to the High Court and the lower courts as to the state of the law. And in discharging that duty, it must produce judgments that are short, concisely written, focusing only on material facts and not delving on issues that are not germane to the case being considered. Do you consider yourself to have the technical ability and forensic skills to produce a judgment of that kind?
Well, I'm a work in progress. I'm a work in progress in the sense that obviously the style of writing for the first court is different from the SCA. I have produced during that period, I'm left with 2 judgments, but I've produced 8 judgments which I've authored, and I have also co-authored 1 dissent with a colleague, and I've also co-authored a judgment which was allocated to me as such. So I am not going to sit here and tell the Commission that I'm 100% there when it comes to judgment writing. It is a work in progress, but what I can tell the Commission is that I have an appropriate understanding of what the issues are, and I articulate those issues in my judgments, and my judgments have never had to be reconstructed, causing difficulties for the presiders. But there's what I have identified as obviously overwriting, and that's what I'm calling work in progress. But the Commission can rest assured that I have not held back judgments. I write them swiftly, and yes, you receive comments, but my judgments have not had to be reconstructed.
And you would be aware that in the past 3-4 years, some 16 judges of the SCA retired, and others were elevated to the Constitutional Court. And in the result, wealth of experience and expertise was lost. And I want you to do some self-introspection and self-assessment and tell this Commission that whether you think that you would be a worthy appointee to that court.
I think my starting point is that I'll never, ever, individually even try to attempt to match the wealth of skill that has been lost to that court. And I would not want to be evaluated on that basis. The basis I would want to be evaluated upon is that I know myself to be a good commercial lawyer. I'm not going to be, wool is not going to be pulled over my eyes when it comes to a commercial transaction. I've taught, for example, in areas that are considered complex, like business rescue. I work very hard, and my industry shows itself up. And I believe that for the long term, I'm a good investment in the court. And for me, it would be wonderful to be able to be appointed now, because there are people that I'm still learning from, and I have more than just potential. My potential is realizable in real terms. And I say that because it would be difficult to try and profess to match the skill that has left that court. And comparatively speaking, I do want to say that even though I don't have a long years of judicial experience, I bring to the fore a range of experience that has been useful in commercial law, basically, that's my strength.
Thank you, Judge Siwendu. Thank you, Chief Justice.
Thank you. Minister?
Yeah, thank you, CJ. You have dealt a bit with the matter of the Minister of Police and Vuyani Gamane.
Yes, that's
I think
correct.
it's the one related to the Criminal Procedure Act and the Domestic Violence Act.
Yes, that's correct, Minister.
And you said in terms of Section 40Q of the Domestic Violence Act, or Section 3, it gives more protection than the one in the section in the Criminal Procedure Act, if I heard you correct. I want to get what is the difference and how does it afford that protection more
Well-
than the one of the Criminal Procedure?
Well, under the Criminal Procedure Act, Section 41B and Q, an accused, I shall put it that way, must have committed a scheduled offense. Yet the Domestic Violence Act doesn't necessarily, Section 3 envisages all sorts of harm rather than physical harm. And it doesn't put a threshold in terms of the kind of violence that must be perpetrated in order to effect a lawful arrest. And so the point that the judgment is raising is that because Section 3 is incorporated there, an arresting officer doesn't need to be satisfied that a Schedule 1 offense is committed. As long as there is harm, they can then effect a physical harm, they can then effect a lawful arrest. That's where I find that by incorporating Section 3 under that section, the threshold for effecting an arrest is not as high as when you are dealing with a scheduled offense. That's why the protection there is higher.
Thank you, CJ.
Thank you. Commissioners, I was given dictatorial powers by those who were present here before we started, and those who were not there are bound thereby. By virtue of those powers, I will allow only one question unless I'm really persuaded to grant another one. Okay. Commissioner Matolo Tlepu.
Thank you, CJ, and good afternoon, Judge Siwendu.
Yes.
Good afternoon.
Good afternoon, Commissioner Lep.
All right. I know that, if I'm correct, you served at a special tribunal
That's
court.
correct. Yes,
and you
that's
haven't said
correct.
anything about it so far. The reason I'm asking, there's an outcry about gender-based violence to be given at least special attention in special courts. Having served in those special courts, do you think it's a valid request? Or how fast do these courts, the special courts, work in your experience?
Well, I'm not necessarily experienced in special courts, but I can talk about the special tribunal because that's really an administrative a structure created to fast-track recovery of state resources, basically. I think that the difficulty is stretching the resources of the state, really. And I think whilst there's value in creating these structures, if there isn't sufficient resources, then they get limited in their ability to perform. So one is walking a tight balance in the sense that I understand that especially the magistrates' court, they've created special courts to deal with, for example, domestic violence. And maybe more resources need to be put in what already exists and to improve efficiencies rather than, having a proliferation of institutions because they call for a demand from the same purse, basically.
I'm afraid to ask the second one, but I'll
Thank you.
abide.
Okay. You may be aggrieved, but you abide. No, thank you. Commissioner Singh.
Thank you very much, Chief Justice, and good afternoon, Judge Siwendu.
Good afternoon,
Thank
Commissioner
you.
Singh.
In the pack, there are letters of support and comments from various bodies. And I note one there from Ramaslale Legal Consultancy. It's on page, it's marked as letters of support.
If you can direct me to the page.
Doesn't have a page number, but you'll first see GCB, then Nadell under your name.
Are you able to help me with the page of the pack, Commissioner?
It's in the book where titled Feedback from Law Bodies.
Oh, all right, yes, yes, I've got my own copy. And this is from?
From Ramaslale Legal Consultancy,
Oh,
letters of support.
yes,
Have you located it?
yes. I remember reading this letter and I was very touched.
While you find it, in this letter they say under C, I've noted that she strongly focused on substantive law rather than protecting the food chain and marriage by firstly focusing on procedural aspect before substantive law.
Yeah.
And then you say it is important that she improves the tradition in dealing with each and every matter by firstly considering procedural law. Can you give a brief context to these statements and how do you think that your approach is best suited for the SCA?
Yeah, so the author of this letter actually appeared before us in the Supreme Court of Appeal in a matter involving his admission as an attorney. And I was surprised to receive a letter of support from him. And I think it's an issue, for example, the GCB is raising. The simple fact in this matter is that I found that the Court of Appeal has no jurisdiction to deal with the appeal because the decision of the lower court was a nullity. There's a kind of a view that I should have had recourse to 173 to address this issue. And I recall having a lot of debates with the other members of the panel, the gateway to going directly to the constitutional provision, when in fact the grounds for granting leave to appeal are a jurisdictional fact defined by the legislation, seemed impossible to me. So I suspect that he's possibly referring to that, and I think the bar also raises that issue. And Judge van der Merwe, senior judge, concurred in my decision in that matter. And I feel that, efficiency of the courts, and especially when the correct procedures are not applied, is also equally meritorious of protection. And also because there are consistent decisions of that court which deal exactly with this matter. And I couldn't find that I could overrule them unless they were clearly wrong. And I mean, it's a minority judgment, but I think that it's the correct decision for the court.
Thank you, Chief Justice. He is supporting your application, but thanks.
Yes, but I mean, you should say that he says that I'm warm and I'm welcoming, and he says very, very good things about me, which I also need to hear.
Commissioner Marumuagai.
Thank you very much, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
I initially had two questions for you, but I had to abide in respect of the decision that has been taken. I wanted to ask you a question on the case that you wrote on surrogacy.
Yes.
But you touched on some of the aspects that I was concerned about, but I'll leave that.
Yes.
The Supreme Court of Appeal, I'm not sure if I'm right or wrong. It doesn't seem like it ordinarily attracts amicus curiae
Yes.
as much as the Constitutional Court and some of the high courts actually do.
Yes.
But in the rules of that court, there is a provision that deals with that aspect.
Yeah.
I just want to understand from you, when somebody wants to apply to be an amicus in that court, how do they, or what should they do to go, or how do they go about it? What is the requirement for them to ultimately be accepted as amicus?
I am not going to profess that I know the answer. I definitely know it from the perspective of the High Court. I mean, where a court is requiring independent assistance under Rule 16, they can call on an amicus. I haven't yet seen it in operation at the SCA, so I won't profess that I know how that would
I'll live
operate.
with that. I'm fine with it. Thank you, CJ.
Thank you.
Thank you. Commissioner Nochesi, and I will,
Thank you, CJ.
anyone who is covered, feel free to say I'm covered.
Justice, first let me say your track record as an attorney and also commercial. I thank you that you are still here. You are still applying for the court up there. Very few women in particular with the background that you bring. I'm just troubled by some comments from the GCP.
Yes.
Yeah. If just because I don't want when we deliberate that you have not been given an opportunity.
Yes.
There's this, in fact, the whole, but at the end they support you. If you see their conclusion, they support you. But this is paragraph 9 of this.
Yes.
That was my concern. I just
I'm
want-
sorry, Commissioner Nochesi.
Paragraph 9.
You were speaking too softly for
Okay,
us to
I'm
hear.
saying I refer to paragraph 9 of that comment
Yeah.
of the GCB, the candidate's linguistic and communication skill. As far as I know, you speak fluently, very, even no judgment, but what would you say to this?
Yeah.
I was surprised when I'm reading this.
Yeah, I must confess, first of all, I think that we tend to be enamored by our judgments. So, and yet, actually, they are for the public. And if the points don't come through as well, or they are not as well articulated, I mean, one takes that feedback. And I just want to say unequivocally that my responses are not to reject what the GCP is saying, even though I felt the sting of the comments. I do want to say that I've looked at each one of them, and for me, all I could come out with is that there are instances where I could be sharper, right? And I accepted that unequivocally. But some of the issues are really a question of style. For example, the surrogacy case that they are raising. I mean, that judgment, there are no principles of law in that matter, right? I could be relying on. I was developing the statutory provision. I also accepted the criticism that they couldn't understand who the parties are or the style of the writing. I think what what pulled wool on my eyes, because it was an ex parte matter, and I was writing a sequel to a previous judgment. But I accepted their comments, because some judgments you are writing for a particular segment, which is not necessarily widely accepted. The question of, I didn't understand what it means to say judgments are elementary, and they seem to suggest all the judgments are elementary, which I disagree with. I mean, I've given you my judgments in competitions appeal and so forth. There's absolutely nothing elementary about those judgments, in my view. And of course, I mean, there is also the complaint around the old mutual matter. I mean, it was extensive application of the principle, but as far as I'm concerned, each segment had a proper evaluation of why I reached that particular conclusion. So whilst I accept that I can be sharper, and I think the SCA, and they say that my judgments have matured, the SCA truly offers me the opportunity to show my scholarship and my skill. And I think the Commission needs to be aware that we write under incredible pressure, and we've got to produce things in the shortest space of time. So that's the answer I can give.
Thank you. I mentioned that I think we have been interviewing Judge Siwendu for about an hour. Commissioner Steinbeck.
I'm covered, thanks, CJ.
Thank you very much. Commissioner Shabangu Mdawe.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Judge, I'm not going to ask you any question about your work as a judge. I think a lot has been covered.
Thank
But
you.
I'm more interested in your contribution towards transformation
Yes.
of the judiciary. Can you share with us as to what is it that you can contribute towards transformation?
Yes, so, I mean, my contribution is more around training and development. I have been working for SEJE for as long as I can now remember, in training aspirant judges on the business rescue component of the Companies Act. And broadly, time is really very limited. I accept speaking invitations, especially around issues involving women and how to find one's way inside the judiciary. So, since becoming a judge, my broader social role has really been reduced, and I'm obviously a mental health advocate, and that has really captured more my attention. I am also involved with IWAJ, and hopefully, if clarity of my future direction goes, we are looking into the issue of mental health inside the judiciary. And I think those are important social questions, and they are in themselves empowering and transforming in themselves. Yes.
Thank you, Judge. Thank you, CJ.
Thank you. Commissioner Lucas.
Thank you, CJ, and good afternoon.
Good afternoon, Commissioner.
Judge Siwendu.
Thank you.
Yeah, I actually, in terms of the questions, in the responses that you have given, you have actually covered me, but I want to comment one or two issues.
Yes.
And then also you spoke about the issues of the GCB.
Yes.
And that you read through all of the comments that they made. Mine was also on the issue that they felt that you are a bit unclear with regards to constitutional issues.
Yes.
But before you respond, one of the things that I really wanted to comment was on the issue of mental health.
Yes.
Because it's also something that is a concern for me, and it's very rare that you hear that someone is really addressing the issue of mental health. So I want to commend you on that specific one. But also, although your document gives us a lot of reading, I should say it is one of the more clear and properly prepared documents. And I want to commend you also on that one. Thank you, CJ.
Thank you, Commissioner.
Thank you very much. I think we have come to the end of this interview.
I do have one point, Chief Justice.
Yes.
If I may be permitted.
Yes. Go ahead, yes.
Justice Siwendu, I want to just come into this issue of the GCB.
Yeah.
And the comment that has been made.
Yes.
And specifically to talk about the Living Hands judgment.
Yes.
That judgment is on appeal.
Yes.
So then we should probably limit what we can say about it.
Yes.
But there's just one point I just want to make sure that I don't leave the interview not being sure about where you stand on it.
Yes.
Which is this debate around pure economic loss.
Yes.
Now, it's mentioned 4 times in your judgment, but it is never defined. What exactly is pure economic loss as you understand it?
Well, I think a claim for pure economic loss is one that is not associated with personal or it's a
Property loss. Or,
yes, or property loss or personal loss. It's really like a
no,
almost
that's sufficient. I'm actually happy with that
yes,
answer.
yes.
And now the critique then is, if that is so, our common law of delict, whether that's right or not is a different issue. But your point is you're looking at the law for the future, which is a positive thing, is reluctant to recognize liability for pure economic loss,
Yes.
except for certain exceptions.
Yes.
And it seems to me then the point they're trying to make is that in the judgment itself, there's no full explication about why that liability is imposed.
Well, I do deal with it.
Yes, I know you do, but that's what I need you to give you a chance to say it is in this paragraph,
Yes, I'm
and therefore
going
the criticism is unfair.
Yes. No, I specifically deal with it. Let me just go to my own bundle because I did mark it up. I specifically deal with why a claim for economic loss should be recognized in this instance. Right. And just give me. All right. I start at. If you look at from paragraph 174 onwards, I deal with the question of the wrongfulness, and I deal because I consider that as part of the policy consideration and why a claim for economic loss should be extended in these circumstances. I go on in one up to through 178 and so on, and I say that because of the nature of these funds being investment funds, and the role that the manager played in relation to developing this structure, that this should be recognized. I mean, I rely on the judgment of Froneman and why policy considerations demand that this should be recognized. And I think from that paragraph right up to 184, it is designed to address that and why I think our law can accommodate this claim outside of developing common law.
Yes, thank you. There's a difference, of course, between not dealing with it and then someone feeling you should have expounded on it.
Yeah.
Would you agree?
I do.
Yes. And then there's also another interesting judgment, but you are a minority there,
Yes,
which is this whole debate about once empowered, always empowered.
yes.
Yes, I've always wanted to ask you outside of the court hearing about that judgment. I think this is my chance. Because it's always struck me as odd that the law would take the view that if you get a BEE deal once and the BEE partner is bought out, you have no ongoing obligations to remain empowered.
Yes. Well, that was there were many points of departures in that in that matter. And if you ask me, I think even if at some point one may say that my conclusion is correct, I think it was an absolutely well-reasoned judgment. And the simple point there is that we're dealing with a mining right. And the mining right is accorded in terms of the legislation. And it's clear to me that as long as the right holder holds that right, and the requirements for empowerment are inextricably linked with the right, whether or not the BEE partner exits, it doesn't take away from the obligation to have one. And I found that that's the very purpose of that legislation. And I wish that it had also been included in the commentary.
You mean by the GCB?
Exactly.
Thank you, Chief Justice.
Thank you. Thank you very much, Judge Siwendu. Once again, thank you for availing yourself for this interview. We appreciate it very much. You are now excused.
Thank you. You get them to put a little bit of money on it. Thank you to the Commission.
Thank you.